Sydney Vizard for Rebel News. It's been 524 days since Anthony Oleanic, Chris Carber, Chris Lysak, and Jerry Morin were arrested and charged in the town of Coutts. Multiple publication bans have been issued, and the Crown prosecutor continues to fail to provide timely and complete disclosure. The four men were supporters of the Coutts blockade and attended the 18-day peaceful demonstrations, which blocked the largest international border crossing Alberta has with the United States. This blockade was against vaccine mandates and COVID restrictions, a sister protest to the Freedom Convoy in Ottawa, and the hundreds, if not thousands, of demonstrations across Canada at the time. They were arrested February 13th and 14th, 2022, during the execution of warrants near the Coutts blockade, which arose from the ITOs, warrants that didn't require a judge's signature before being undergone. They face multiple charges, including mischief, weapons, and conspiracy to murder RCMP. Their arrests occurred hours before Justin Trudeau invoked the Emergencies Act to control peaceful demonstrations across the nation by any means necessary. Many argue Trudeau capitalized on the arrests to show justification in use of force by police to remove peaceful protesters, notably in Ottawa. In Coutts, before Trudeau could announce this, demonstrators decided, upon hearing the news of the arrests, that it was time to end the blockade, to send a message that this was a peaceful movement. The four men were denied bail last summer with reasoning hidden by one of many publication bans. Multiple publication bans have been sought by defendants, preventing some details of the story from being revealed at this time. Rebel News is in the process of obtaining and reviewing these documents to understand just how much is off the record. We will provide updates on this in the near future. This July 25th to 28th, the four are expected to be back in court, with one attending the Monday before, where the judge is expected to make a ruling on a smaller issue to the main trial. We will provide further updates on the proceedings from the courthouse as they occur. As an independent media outlet, we don't take taxpayer money from Trudeau. Instead, our existence relies entirely on our donors who support the work we do. If you want to help cover the cost of us attending these proceedings and obtaining relevant documents, go to rebelinvestigates.com and donate. The four were back in court early June, which was originally set to be their 3-week trial. Instead, an adjournment was called. Defense lawyer Greg Dunn, representing Jerry Morin, expressed deep concern over the Crown's failure to provide complete disclosure. Quote, "There are 3 breaches that have been made by the Crown in this ongoing matter. 1. Failure to provide full disclosure. 2. Failure to provide timely disclosure. And 3. Failure or refusal to respond to additional disclosure requests." At that time, there had been 13 disclosure packages provided to Dunn, some just days before that court appearance. Not being able to provide disclosure documents in a full and timely manner is a serious issue, and unfortunately, all too common. We heard from Chad Williamson of Williamson Law previously, who informed us of exactly what this can mean for the defense.
In the Chris Scott case, this is one that we've been fighting over disclosure for almost a year now, when it actually turned up in trial that Alberta Health Services had a whole bunch of emails that related to the investigation and prosecution of Chris Scott, and that they didn't turn it over.
Chris Scott is the owner of the Whistle Stop Cafe, who decided to stay open during the pandemic, allegedly lacking compliance with draconian Alberta Health Services COVID mandates. It's worth noting his restaurant and gas station, which supplied his entire town, was what they were trying to shut down. It was discovered in that case that a mountain of evidence was not originally provided and did not show favorable for AHS. Barrister and solicitor Martin Regman of Williamson Law highlighted for us in today's interview the level of obligation a Crown prosecutor has in providing disclosure, even if that evidence works against the prosecutor's claim on the accused. We also discussed what impacts new evidence favorable to defense would have if other cases were reliant on the same disclosure information. Keep in mind, the 4 men from Coutts were the ones who faced the most serious charges and have been held in pre-trial custody for over 500 days. But many other cases from Coutts have yet to make their way through the courts, notably for others arrested during those same execution of warrants. This delayed and incomplete providing of disclosures may also prove to be a hindrance on other cases such as theirs.
I'm Martin Raymond. I'm a solicitor and barrister with Williamson Law.
Williamson Law has done a lot of work with Rebel News and with the Democracy Fund as well. And part of the work of Williamson Law, the firm, has been assisting some of the individuals from the Coutts blockade scenario. Obviously, there's a lot of court cases that are taking place. There's a lot of different law firms that are involved, and lawyers specifically, of course, that are involved for their specific clients. If it was the case, exculpatory evidence is found by other lawyers on another case, does that affect your client and your case?
Yeah, in a hypothetical situation such as this, and it's probably has happened before in our jurisprudence here in Canada or other jurisdictions that use the same common law system as we do here. If there are two matters that are tied in some manner or some factual matrix, if such evidence is found in one matter that the Crown is using in a second matter, and it's pretty damning and quite relevant, and it influences the first matter, and potentially shuts that matter down, and the Crown has no choice but to drop the charges. If that evidence can anyway be used in the second matter, then absolutely, yeah, it's something that'd be very interested, and it would greatly influence the second matter. Absolutely, the Crown has an obligation to provide all relevant and material documents, evidence that is relevant and material to any somebody's criminal proceedings. It's not up to the Crown to decide on the relevance and materiality of that evidence, because they may think that something is not relevant and material, and therefore it's up to the defense counsel to make that decision whether they want to use that evidence in defending their client. So the Crown has a duty to disclose everything that comes up in an investigation, and the fruits of an investigation to defense counsel. Yeah.
Even if it makes their side look bad.
More so if it makes their side look bad. We've had this in numerous cases. The Crown is not allowed to hide or withhold any evidence, especially if it affects their case against the accused. So if it's damning and negative to the Crown's position, that has to be disclosed. They cannot withhold it.
Here at Rebel News, we've been following this story from the very beginning and will continue to do so to the very end, to see what justice is had not just for these four men, but for all of the individuals who've been ticketed and charged because of the Coutts blockade. And now it's been over 500 days they've spent locked out, without having been found guilty of a single crime. To help us cover the cost of attending the four men's court proceedings next week, go to rebelinvestigates.com and donate, so we can bring you the coverage the mainstream media won't. For Rebel News, Sidney Fazard. If you want to see our previous reports on the four men charged with conspiracy from the Coutts blockade, or for what we're going to be covering in the weeks ahead, go to rebelinvestigates.com and donate.